When Tort Museum opened in 2015, there was international and national coverage, wide coverage. One reason is it's the only law museum in the entire world, whether tort or otherwise. And that is a detraction on the legal profession. Because if we don't bring the law to the people, it will evoke what my father once told us. If you don't know the law, you don't use the law. If you don't use the law, you lose the law. And the law of wrongful injury is perfectly understandable to high school students and to college students. The essentials should be taught because it's the most significant way, without asking anybody's permission, where wrongfully injured people can go to court, have a trial by jury with a contingent fee lawyer. That's why it's called one of the great private pillars of our legal system, stemming from medieval England, established the trial by jury, and it came across the Atlantic and was decisively determined to be a core pillar of our freedom against King George III. You'll see that torts are everywhere. You'll see in the presentations and in the leading experts in the field today just what we mean by the law of torts and how clearly it can be conveyed. We are preparing a high school and college curriculum. We have students here from Mount Holyoke, the first college to teach tax law. And it was seen to be indefensible. How can you teach tax law to undergraduates? But Professor Fox did it very successfully for many years. We have here students from Gilbert High, which I graduated from, and they can learn it as well. And Rick Newman is doing a high school curriculum for that purpose. We hope to expand the museum to include a courtroom, theater, and other facilities, and put the museum on the road. So it's a mobile museum. It goes all over the country, day after day, educating people about this critical way to protect and defend themselves and deter unsafe practices. We also hope that more people will recognize that as part of our public education, we have to learn about this and other forms of law and not leave it to the lawyers. First of all, for the students, you're part of historic first, the first National Tort Education Day in history, and we hope that you'll see in future years similar events in cities and towns throughout the country, just like Memorial Day or 4th of July or Labor Day. Because nothing affects people in our system of law more than the law of wrongful injury. And you've seen enough examples, but there are only a few of the totality of the ways people in a complex industrial society can get wrongfully injured. Now, before we get anything changed, we have to develop a sense of indignation, a sense of moral indignation. Our country's full of people who know a lot in their heads, they have no fire in their belly. What you heard today were people who knew a lot in their heads and they had fire in their belly. You see? So always ask yourself, do I have fire in my belly? That's what breaks your routine. The reason why there aren't many students filling this church right now is because they don't have fire in their belly and they don't have the right teachers to give them the wisdom to recognize what they don't know about what they don't know. So here's the first way to get indignant about corporate domination of our lives. Remember, the Constitution starts, we the people, right? You've read it. It's we the people. It doesn't say we the corporation. It doesn't say we the Congress. It says we the people. Corporations, companies, political parties, never mentioned in the Constitution. Why do they rule us? Because we let them. We let them. So, in this audience are some of the leading fighters to preserve your right not to be wrongfully injured. And your right, if you are wrongfully injured, to achieve a remedy. You heard Greg Kafuri, his son, Jason. You're not going to get tort reform in Oregon with these two men in Portland. You say, what? Just two people up against these Portland Business Council and all these lobbyists? It never takes more than 1% of committed, concerned citizens reflecting a majority opinion to turn around a state legislature or a Congress. We've done it. People in the audience have done it. 1% is 2.5 million adults in 435 congressional districts. Can you imagine if they spend 300 to 500 hours a year connected with each other and they summon the senators and representatives to their own town meetings, no flax, no intermediaries, no voicemail, and read them the Riot Act, and they represent a majority of opinion, conservative or liberal, about which there's huge support. Many, many changes in this country are supported by conservatives and liberals. But the powerful interests want to divide us on the issues where we disagree and make it as if that's it, that we don't agree on living wage, we don't agree on universal health insurance, we don't agree on cracking down on corporate crooks, we don't agree on a fair tax system, we don't agree on waging peace instead of getting into these quagmire wars, we don't agree on clean air and clean water, on good schools and repaired public services. Are you kidding? That comes in 80, 90%. 90% of people want to break up the big banks in New York that are too big to fail and are bailed out by the taxpayers if their crooked ways collapse their banks, as they did in 2008-9. So here's step one for your indignation level. Corporations throughout U.S. history have maintained a bizarre credibility. We're not talking about small businesses. These are the giant corporations with hugely paid CEOs and no rights for the shareholders and usually anti-union. Why do they have credibility? Look what they said no to and eventually lost. Sometimes took centuries, decades, generations, but they lost. I'm not even going to talk about what they say no to that they have won for 300 years. Here's what they said no to. They said no to the American Revolution. That's a pretty good start. They said no to the abolition of slavery, the cotton corporations, plantations. They said no to women's right to vote because women were spawning a consumer revolt and they didn't like child labor. They said no to public schools. They said no to labor unions and fair labor standards in the Industrial Revolution period. They said no to the abolition of child labor. 8, 9, 10-year-old kids in dungeon coal mines, foundries, and factories, instead of going to school, instead of having those jobs taken by their parents because they're cheap, they're disposable. They said no to progressive tax system. They said no to the entire reform package of the populist progressive changes at the turn of the 20th century. They said no to Medicare. They said no to Social Security. They said no to the environmental movement. They said no to the consumer auto safety movement. They said no to the job safety efforts that established OSHA. They're saying no to the civil justice resurgence. How many no's do they have to say before we have them lose credibility? They don't lose credibility because they're not human beings. They're not as vulnerable as human beings. They're immune. Their impunity knows no limits because they control the state. They control the forces of political power. They plan our elections and our government. And as some members of Congress have said, they own the place, meaning Capitol Hill. Well, that's one stage. I hope you're getting steamed a bit here in Mount Holyoke and so on. All right, the second is you should talk and you should connect with the people here in this audience. They did it on less than 1%. You have people here, Donald Ross helped organize student groups with me, starting the Massachusetts PIRG and PIRGs all over the country, public interest research groups. You have fighters to preserve the civil justice system, Pamela Gilbert, up from Washington, in addition to the speakers, of course. You have John Richard, Russell Mokhiber. You have the fellow at the Civil Jury Project, the only one in the country, NYU Law School, and you heading that way, Michael Shermas. You have a lot of people here. You think they're giving up? You think they say, oh, because we don't have thousands of people and millions of dollars, we can't deal with these huge corporations? Nonsense. Our country is full of examples where all these things I just pointed out, they were pursued and the corporations were beaten by less than 1%. Even the broadest mass movement in our history, the civil rights movement, never had more than 1% devote 300 to 500 hours volunteer a year. That's, let's say, the rough amount of time we give to our hobbies. 300 to 500 hours a year. Now, it's important to recognize that a lot of your education and a lot of our education was full of myths. Like I learned Columbus discovered America until my father sat me down and said, sit down, son. He invaded America, and he killed a lot of natives who were always there long before he showed up looking for gold. And in colleges, it's unbelievable, the myths we learn instead of the realities. You're fortunate because you're here because you have a lawyer who's a professor of politics, Christopher Pyle, in Mount Holyoke. He's a national expert on torture. Do you think when he teaches the students about the international and domestic laws against torture, he uses the phrase enhanced interrogation, Bush Cheney style? And do you know there are millions of college students who, when they touch on the issue of torture in their class, the word is never used? It's called enhanced interrogation. And it's viewed as if it's normal. You got to get these guys, even though it's been shown to be useless for the purposes for which it is used. So here is the importance of tort law and contract law. I'm very glad Ms. Dorshow pointed that out, because here's what affects you. Every day you surrender your freedom of contract. There's not a day that goes by, as students, impecunious as you think you are, that you don't give up your freedom of contract, which our forebears fought for, and which is considered by conservatives one of the pillars of freedom. And at Harvard Law School, we spent one day studying fine print contracts. One day, even though the vast majority of contracts we'll ever sign will be these pre-printed standard form contracts you click on or sign on the dotted line. Does it occur to you that your education should educate you about contract servitude, contract peonage, contract incarceration, credit card, debit card, credit score, penalties, fines, late fees? Did you read any of that? When you bounce a check in the bank and they hit you for $35, did you agree to that? It doesn't even occur to you. Just as it didn't occur to us in the 50s that I was sitting at the Harvard Law School and there was 2 African Americans, 15 women in a class of 560. That's just the way it is at Harvard Law School. What is it today that you're not aware of? What realities are you not aware of? Well, you saw some of them being presented today. Contract law is destroying tort law. We would never believe that years ago in law school. By compulsory arbitration, you agree not to go to court and have your constitutional right of trial by jury. There's no government that can do that to you, constitutionally. But corporations can, because they say, hey, you signed on the dotted lines, page 32, in 6-point type. See the mythology? There's no such thing as consent in those situations. Let's say you don't want to consent to MasterCard, and you're going to go to a competitor, Visa or Discover, same contract. Let's say you don't like the fine print contract of Ford or Metropolitan Life. You're going to go to GM or Prudential, same contract, contract peonage. So here's the importance of it. Years ago, some of our ancestors decided they were going to be good ancestors. And they knew that the government could be corrupted by the merchant class, the corporations. So they started giving us private rights. The two great private rights in this country that are hundreds of years old are the right of contract. That is, you can enter into a contract, you can negotiate it, you can refuse to sign it, you can go to someone else who'll give you a better deal. And the law of torts, when you're wrongfully injured or your next of kin sees that you've been killed wrongfully, you can go to court, get a contingent fee lawyer, that is, you pay only if you win, and have a trial by jury. Those two pillars are called the pillars of private law because you don't have to ask anybody permission to use them. You don't have to beg a district attorney to prosecute. You don't have to beg a legislator to pass a law. You can decide to go to court or to reject signing a contract. So what do the corporations do? Year after year, they're smashing it bit by bit. You lose your freedom of contract, and you lose your freedom of using the law of torts to protect your physical integrity as well as your reputation when it's defamed. That's what's at stake. When you talk to conservatives, have them define freedom, and then tell them what freedom really is in this context. I love to talk to conservatives. I love to debate conservatives. First thing I ask them is this a free country? Well, we're trying to make it a free country. Well, what do you think is free about it? A free market. We want a free market. We don't want government regulation. Oh? Have you ever refused to sign a fine print contract? See how far it gets you with Facebook or Microsoft or the telephone company or the credit company. Just scratch out some of the paragraphs and initial it. Say you want to pay a lower interest rate on your installment loan with the auto dealer. See how far it gets you. They don't even recognize that their freedom of contract has been virtually destroyed. No negotiating power. All right, so what do we do about all this? First, we get rid of this idea we're a litigious society. We're a non-litigious society except corporations suing other corporations and other people. There's a study out of University of Wisconsin by two law professors that, among other things, found that in 1840, ordinary Americans filed more civil lawsuits per capita by far than they do today. First of all, it's very expensive today. 1840. Why are we told we're litigious? Because the insurance companies want us to believe that. They say they're frivolous suits. As Rick Newman asks people when he toured, you have not been toured in a museum until you have Rick Newman tour you in the Tort Museum. It's like every time he tours, it's his first time. He's so enthusiastic. And he says, give me an example of a frivolous suit that isn't dismissed out of hand by the judge who's in charge. And the reputation of the lawyer starts to suffer because they've lost credibility in the court they have to use again and again. We're taught all these myths. Why aren't we untaught these myths? These are the myths taught in business schools all over the country. Do you hear the case? Do you hear the case? Oftentimes just phony. completely contrived by the tortfeasors lobby. A tortfeasor lobby are people who commit torts. Now, what do we do about this? First of all, it's easier than we think to change it. In fact, if we had more time, I could say the following and demonstrate it. It's absurdly easier than we think to change it. You just need a few 100,000 people out of 330 million who are serious about it in the arenas where the decisions are made, state legislative districts and congressional districts. You make a list of all the changes you'd like in the United States of America, and more often than not, it comes down to 535 men and women who put their shoes on every day like you and you. Congress. You move Congress, you move the executive branch, you get a better brand of judges, and the same thing with the state legislatures. But we grow up powerless. We're taught powerlessness. We're taught to believe in elementary school instead of to think. We're taught not to criticize, not to dissent. Everything we like in this country started with dissent. Dissent is the mother of assent. Dissent is heroic, as we know from whistleblowers that are in the news these days. So here's the list. Lists tend to be a little boring. I'll try to make them a little exciting. Number one, we need a better brand of judges. Too many judges are elected by money in too many states. Not all states have elected judges, they're appointed by the governor and confirmed state legislature. But after all, when a plaintiff invokes a cause and goes to a lawyer, you surrender a lot of the future of that case to the competence or incompetence and value system of the judge, who can push the jury around more and more. So we need to take more interest in judicial appointments and judicial elections. There's no reason why most of them have to come from the business community. They should come from labor. They should come from public interest lawyers. They should come from law professors. They should come from people who aren't even lawyers. There's no requirement a judge has to be a lawyer. Why do you keep judges coming from a monopoly? A monopoly that most people can't afford. 1.2 million practicing lawyers, unless they're on a contingent fee. The second, we need citizen action groups. The other side has groups against lawsuit abuse, supported by industrial corporations, insurance companies, banks, you name it. There's only one or two citizen groups for universal justice. What's the excuse? It gets down to the third point. The trial lawyers of America, with very few exceptions, are not stepping up to the plate. They help build the tort system and expand the rights of wrongfully injured people. They have not committed the resources to defend it. Let's be very candid here. The Museum of Tort Law was helped by a handful of foundations and trial lawyers, but the vast majority were not interested. How many Connecticut trial lawyers are in the audience right now? How many Connecticut plaintiff trial lawyers are there? 3,500?
1,200.
1,200. Here it is, Connecticut. It's a small state. It's not Colorado. We're not asking them to go from Grand Junction to Denver, right? That's part of the problem. They pick the fruits out of the trees while the forest of civil justice is dwindling. Lawyers have to be both attorneys for clients and they have to be lawyers looking out for the larger administration and access of justice in our country. Next is education. Why aren't we teaching contract rights and tort rights to our high schools and colleges? I went to colleges like many of you gone to, never heard the word tort law, never heard the word civil justice. I took politics, never heard the word. It's bizarre, isn't it? No, it isn't bizarre. It's not accidental. Education today is an obedience institution to the power structure. There's no reason why these curriculums cannot be developed. Rick is developing a high school curriculum which can be developed into a college curriculum on civil justice, trial by jury, tort law. Any professor could have done that in government, political science, or law school. There just aren't enough leaders in this country. Too many followers. Fourth, jurisdiction is a jury duty. How many times, Rick and I and many in the audience, what about jury duty? Oh, I got out of it. You know how many people died for our jury system? It was the number 2 objection by our revolutionaries in 1776 against King George. They accused him of restricting their right of trial by jury. They really used the courts in those days because the courts were a barrier against tyranny. It just so happens in this little document, there's a whole mess of rights, aren't there? Civil rights, Bill of Rights. You know how many duties there are? 1, jury duty, 7th Amendment. And not even explicit, it's implicit. Namely, hey, if you can't make jury duty a civic obligation, you can't have juries. And most people laugh about getting out of it. They laugh about sitting in a jury box and being able, without any power or influence or money that they bring to the jury box, to hold giant companies like Exxon and Pfizer and the Bank of America and General Motors accountable, and Boeing, the latest example of corporate criminality. Jury duty has to be self-imposed. In Washington, D.C., 70% of the people, I am told, throw away the summons. And the D.C. government doesn't have the resources to go after them. They just throw away the summons for jury duty. Just like that. That's the lack of education. That's the lack of applying the wisdom of the legal profession, branching out to reach millions of people every year. Just think, there are 60,000 trial lawyers in our country practicing, at least. If they just spoke to 1,000 people total in 1 year, little groups, they'd reach 60 million people. What are they waiting for? The next one is court budgets. What do you think the average court budget? The state budget is to the executive branch programs, the safety nets and regulations and services, and the legislative branch and the judicial. What do you think the average percent of the state budget for our courts in the land? What do you think they are? Anybody want to yell it out? 1%. Huh? 2%. The technique, of course, by those who don't want to have you to have ready access to the courts so that justice delayed is not justice denied, is to keep that down. So you file a case, there's a delayed number of cases piling up, the judges are overworked, they're behind in their docket. What do? They pressure settlements. They pressure settlements which often work against the plaintiff more than the corporate defendant in tort cases. As a result, the number of jury trials going like this as the economy and the population grows is going like this. Some people talk about it becoming extinct, going like this. The critical way where the citizenry can judge and pronounce on the misdeeds of the rich and powerful. Then there is, of course, the insurance companies. They're supposed to be interested in loss prevention because they have fewer accidents, fewer injuries, fewer fatalities. They have fewer claims. They can make more money. But not if they keep raising the premiums. I mean, an insurance company would much rather charge you $1,000 and pay out $500 in claims than charge you $500 and pay out $250 in claims. Because then they got a lot more money to invest and get returns from their reserves. We should have higher expectation levels for the insurance companies like Travelers and Geico and Aetna. What are you doing to your corporate clients to say, you got to have the workplace safer, you got to build these products safer, you got to provide adequate labeling and warning, you've got to clean up the environment? That's a lot of power, the insurance company. If we don't have the expectation level, they laugh all the way to the bank. And then there's the overall effect of all these lawsuits economically. When wrongdoers have to pay, that means they internalize their costs. They don't throw the pollution cancer risk on you without having to pay for it internally through lawsuits, let's say. When they have to pay for it internally, their economic calculation kicks in, doesn't it? Because it affects their profits. It affects the bonuses of the executives. The more these costs that they inflict on innocent people, death, injury, disease, trauma, property damage, the more they have to absorb, the more they'll put their ship in order. This happened in medical malpractice and anesthesiology. Anesthesiologists, some of them were pretty reckless, so much so they exposed themselves to the gases in the operating room. Then they were hit with some pretty hefty medical malpractice. And the word got around. It's going to cost more for you to be reckless than it is to be safe. And they improved the situation measurably. Let me end on this note. There's a gift bookstore out there. It's not designed for decoration. It's designed for motivation. It's designed to have people read it and have a higher estimate of their own civic significance in life. If you have a modest estimate of your own significance, you are not going to reach for justice. You're going to just get along by going along and swallow your grievances and complain and get frustrated and take Valium, whatever. Okay. There are also T-shirts and memorabilia, not just for a memory. Yeah, memories are nice. Years from now, it's nice to say, I was here on a certain date. It's to provoke discussion. When you walk around Mount Holyoke or Gilbert School or the absentee Northwest Regional High School students, they'll say, what's this? Tort Museum. What's this Pinto fire? Starts discussion. All democracy starts with conversations. 1, 2, 4, 16, 30. Then you hit critical mass. Small talk, which is rampant throughout all cultures, is replaced once in a while by serious talk. Also, if you have some time to further tour the museum, I think Rick's got it open until 7 o'clock. You have wonderful people there. And you can look it over and see if you want to persuade your fellow citizens and your fellow students to come for scheduled tours in the coming months, especially in the beautiful New England fall season. I want to end on this note. The important thing in our society is not just to have a chance. It's to have a chance to have a chance. That's what access to justice is. It doesn't guarantee you justice. It guarantees you a chance. And it's most facile for corporations to cut you off from having a chance to have a chance than having a chance, because it's more remote. Keep that in mind, please. The other thing to keep in mind is, I don't think this was mentioned, but the total verdict and settlement under the tort system is abysmally small. It's abysmally small. I'll give you an example. The entire amount of money that medical malpractice victims get, and not more than 1% get anything. Most malpractice victims, one, they don't even know it was malpractice. You know what happens in an operating room, or you take a misprescribed drug. It's very hard to connect the two. That's for medical journal studies to do. And number two, they don't want to sue their doctor. And number three, the doctors have all the expert witnesses to vouch for them. The entire payment, we're talking, look, consider this. Styles of violence that are subjected to the rule of law in your favor, if you're gravely injured, the ones that come from corporations are the most ignored. So you have street violence, it's headlines, evening news. But as Professor Peters pointed out, 5,000 people a week in this country die from preventable problems in hospitals. Never mind clinics and doctor offices. The Johns Hopkins study just said hospitals. That's more than 9/11 every week. Now, you can say it's not intentional. Well, in some cases, it's unctuous greed and knowing incompetence. But that doesn't help a mother or father who's lost a child say, well, sorry about Susie, but, it wasn't intentional. It was preventable. It was hospital-induced infections. Who doesn't know about that? Hospital incompetence, accidents in hospitals, wrong combinations of pharmaceuticals, and on and on. So here's how much is paid out to the lucky few. The underutilization of the tort system is almost 98% of serious wrongful injuries never see a lawyer. The total payout is less than a half year's profit of Google, less than a half year's profit of AT&T. And they say that verdicts are going crazy. They're going to use all this in Georgia coming up next year. The business lobby is readying a massive strategic attack to destroy the law of torts in Georgia and then spread it around the country. And the main opponent of this is a young lawyer who's right here now, Matt Wetherington. Where are you, Matt? There he is. So when you hear about the civil justice system, just ask, well, you think it's too litigious? What are you talking about, quantifiable? You think there's too much verdicts and settlements? What are you talking about, quantifiable? You think people use it too much? You mean 1 or 2%? That's too much? I want to thank you all for coming. Obviously, I want to thank Rick Newman and Remington, Greg, and the sterling speakers. It is really hard when you know a lot about a subject to pull it off in 20 or 30 minutes. You're telling me. And they did a terrific job. It's being videotaped. It's going to be used all over the country. I want to also thank the support volunteers, too many to mention, who made this possible. I want to thank some of the teachers who lent their wisdom to recalcitrant students and got them here. And also I want to thank the audience. You showed up. Half of democracy is showing up. I bet you wished your neighbors and friends and co-workers were here. Why weren't more of them here? Because we've got a lot of education to do. Many times in the 4 years this museum was open, we have wondered why everybody who goes through it, almost without exception, is totally overwhelmed and pleased with what they've learned. Eye-opening, empowering. One person came from New York, he says, I'm a museum junkie. I've been to over 100 museums. And this is the first museum I've been in that respects my intelligence. Chief Justice of the Supreme Court, Stephen Breyer, came, looked at every exhibit in his meticulous way, and said, this is a, quote, excellent educational institution. A retired High Justice from Mumbai in India came through the museum, and he said to Rick, I know what you people are trying to do. Rick says, what? He says, you're trying to bring the law to the people. Just imagine. What should lawyers do other than bring the law to the people? They are officers of the court. They're quasi-officials. They're not just private citizens. They have a monopoly. And with that comes a responsibility and a duty. The tort law system has to be expanded. The tort reforms have to be rolled back. And as Mark Rottenberg has said, we have to expand the tort system to cover whole new areas that were never envisioned by previous decisions under the common law of torts. That means biotechnology, artificial intelligence, nanotechnology, various invasions of privacy from the Facebook, Google, Amazon, and other worlds. And that is what we all have to do, is don't leave tort law to the lawyers. It belongs to you. It has always belonged to you. And the more you know about it, the more you'll use it. And the more you'll use it, the more you're likely to defend it. The less you know about it, the less you'll use it when you're terribly in need of using it, and the less you will defend it. And we're in the process of losing it. Until we turn it around, all it takes is a few tens of thousands of people scattered all over the country to turn it around. Because you and I know that when people feel wrongfully injured, they want justice, and they'll be on our side. Thank you.
Ladies and gentlemen, Ralph Nader.